So, Milady, I may begin with what appears to be common cause, and I'm sure my learned friends will correct me if I'm wrong. The first is that it's common cause that this area has powerful cultural value, both tangible and intangible. As your ladyship put it, that doesn't seem to be in dispute. What's in dispute is how the significance and how the impact were assessed by the various government parties. It's also common cause that the Khoisan are an indigenous people under international law or a minority group under international law. That doesn't appear to be disputed. And so it's common cause that they're entitled to the protections that international human rights law affords them. It also seems to be common cause that the right to culture in international law includes the right to the protection of cultural interests in land over which the cultural community doesn't have rights. So here it's accepted that the applicants and the other First Nation communities, indigenous people, don't have legal rights under South African law to this land, but their rights to culture to international law still apply and still give them the right, importantly here, to consultation. And obviously this will often be the case because, as I'll get to later, one of the reasons why we protect indigenous people at international law is because of the history of colonial dispossession. And so indigenous people will often not be on the land to which they have a cultural connection. It also appears to be common cause that the right to culture at international law includes a right for indigenous people to be consulted on developments that affect their cultural rights. It also, finally, Milady, appears to be common cause that the court can properly consider what's often called soft sources of international law, judgments, reports of special rapporteurs, general comments by the Human Rights Committee, and so on, which we do rely on in our heads, and I will rely on as well. So that all seems to be common cause. So I don't need to go through the various treaties and the articles that are set out in the heads, because that's all accepted by the parties before the court. It seems that the main point of contention between the amicus and the respondents is whether these international law is relevant at all. And there seem to be sort of two categories of complaints. The first complaint is what I call the cause of action complaint, which is that because the applicants didn't properly plead reliance on the Constitution in their founding papers, the submissions we make to interpret the right to culture in sections 30 and 31 of the Constitution are irrelevant because the applicants haven't properly pleaded that. And so that's the first complaint. The second complaint is that the submissions that we make are based on false factual assumptions. So we say in our submissions and in our affidavit that we assume that there was certain problems, we assume certain things that the applicants allege, effectively, about flaws in the consultation process or what was or was not considered by the various decision makers. And they say, well, those assumptions are false, and therefore our submissions are irrelevant. So I want to deal with each of those in turn. So the first one, the cause of action complaint, it's true on my reading that the applicants don't directly rely on constitutional rights in their founding affidavit. But they do assert them in argument. They've asserted them in the heads of argument. Mr. Dodson has asserted the constitutional rights today. He explained at the beginning how he did, on what basis he did so with reference to the principle of subsidiarity. Whether the applicant is entitled to assert those constitutional rights or not, given the way that they pleaded it, is not something for my client to address the court on. That's a dispute between the parties. But they are clearly asserted, and if the court is going to consider those constitutional rights, it's going to allow the applicant to rely on them, then international law must be considered under Section 39(1)(b) of the Constitution. So I'm not going to enter into that debate, but they have been asserted by the applicants. But it seems to us that in any event, largely for the same reasons Mr. Dodson advanced, it doesn't really matter, because what the applicants clearly do rely on is statutory rights, particularly Section 38(3) and 38(8) of the NHRA. And when this court is interpreting a statute, as you know, milady, under Section 233 of the Constitution says when interpreting any legislation, every court must prefer any reasonable interpretation of the legislation that is consistent with international law over any alternative interpretation that is inconsistent with international law. So even if the applicants aren't entitled to rely separately on Sections 30 and 31 of the Constitution as self-standing rights, when this court is considering particularly Section 38(3)(e) of the NHRA that concerns the obligation for consultation with affected communities, it must prefer an interpretation of that section that conforms with international law over an interpretation that does not. And so what international law requires in this particular situation of consultation with Indigenous people for development is vital to this case. Milady, the second complaint relates to the supposed false factual assumptions that the amicus has made, particularly concerning the adequacy of participation. And there's fairly detailed factual submissions and some of the responses by the respondents about why those assumptions are incorrect. But again, milady, I want to stay out of that. The applicants have asserted, Mr. Dodson asserted today, with reference to the record, why the applicants claim the consultation process was inadequate. What they assert were the problems with that. Tomorrow, we'll hear from our learned friends about why Mr. Dodson is wrong about that, and that's fine. But in assessing that debate, that factual debate, it's important for the court to know what is the standard. What is the standard of consultation that ultimately had to be met? What does Section 38(3)(e) mean? And in determining that, it needs to have regard to international law. So it may be that the court has regard to international law, and it determines that the provincial authorities and the city complied with international law. It may well be that international law supports the respondents in this case and not the applicants. My client's neutral on that point. What it wants to put before the court for its consideration is what those principles are. So, lady, in sum, whether it's treated as a pure constitutional claim or as a statutory claim, international law is essential. The court must consider it. So that then leads to the main subject of my submissions, which is what is the content of this international law. And we go through in the heads in detail all the relevant treaties and identify the relevant articles of the International Covenant on Civil and Political Rights, the Economic Social Rights Convention, and the African Charter, which are all binding instruments on South Africa, as well as the other sources, the United Nations Declaration on the Rights of Indigenous People, which is a very important but non-binding source, the IOL conventions and various authorities. And I don't need to take you through all of that. What I want to focus on is the issue of consultation and what the nature of that right is at international law. And I want to do so in four headings. So I'm first going to just briefly talk about the role of Indigenous people in international law and why they get special protection. Then with the nature of the duty, the nature of the consultation duty, how does it fit in? Thirdly, with what is the content of that duty, what is expected of states? And finally, with the question of free, prior, and informed consent and how that relates to consultation. So, Native, I can begin with the special place of Indigenous people. Indigenous people are given special rights in international law, in addition to the rights that every other person has. And there's special treaties just for Indigenous people, the declarations on the rights of Indigenous people, and special provisions in treaties, especially for them. And I'd just like to summarize what the reasons are for that. And I'm conscious of time, so I'm not going to take your ladyship there. But if one looks at the introduction to UNDRIP, the United Nations Declaration on the Rights of Indigenous People, it sets out why the United Nations thought it was necessary to make this declaration. And there's really three reasons. The first is the history of oppression and dispossession, which we know in South Africa, and ours is not a unique history. All over the world, Indigenous people, First Nations people, have been deprived of their land, their right to resources, whether that's fishing or extractive resources, whatever it may be. And they've been marginalized. They've often been killed, hunted down, genocided. So that's the one reason, is that history of oppression of Indigenous people. The second reason is because they continue to be marginalized in many countries. That this history of hundreds of years of colonization hasn't disappeared merely because we enacted the United Nations Declaration of Human Rights. It continues in different ways. Often these days, the oppression is by private parties who are still trying to get access to the resources of the land that Indigenous people currently or used to occupy. So they need special protection because they're especially vulnerable. And the third is that they have a special and different connection to the land and to natural resources than other people did. Mr. Dodson spoke about that earlier. It's discussed in the Shell judgment that he referred your ladyship to. But there's a special connection that they have with land, with animals, with plants, that requires special protection at international human rights law. So that's why they get additional rights, both as individuals but also as collectives. Most of the rights we're talking about here, your ladyship, are given to the people as a collective, not only to the individual members of the collective. Most human rights are given to individual people as humans. These are given to peoples as collectives, because you recognize it's that collective that has the connection and that has been, in the past, discriminated against and continues to be discriminated against. So if we then look at the nature of the duties, and milady, I have an additional authority that's not in my bundle that I would like to hand up because I found it very useful in just summarizing some of the submissions I wish to make. I have copies for my learned friends. Similarly, there are just two authorities here. The first is a report by the Special Rapporteur on the situation of human rights and fundamental freedoms of Indigenous people. And so if we're talking about I'm talking specifically about the duty to consult Indigenous people when developments are made on their land or that will affect their culture. And the question is, where does that duty come from? If I can take the court to paragraph 41 of this report, which appears on page 14.
I'm with you.
Yes. So on the fifth line, the Special Rapporteur says this duty, or this right, derives from the overarching right of Indigenous peoples to self-determination and from related principles of democracy and popular sovereignty. And it goes on, the UNDRIP affirms in its Article 3 that Indigenous people have the right to self-determination. And the quote after the quote, this affirmation responds to the aspirations of Indigenous people worldwide to be in control of their own destinies under conditions of equality and to participate effectively in decision-making that affects them. The right of self-determination is a foundational right without which Indigenous people's human rights, both collective and individual, cannot be fully enjoyed. Related principles of popular sovereignty and democracy join in opposition to government by imposition and uphold the imperative of government by consent. And then the point we want to make is that the respondents assert at various places that they've complied with this duty to consult Indigenous peoples because they've complied with the ordinary duties under PAJA. They say the applicants and the other affected First Nation communities could always have made submissions in response to the ordinary request for public participation and request for comments. And the point we want to make is that this duty is a different one. It's a duty in addition to whatever ordinary duty administrative officials might owe. It's a special duty to Indigenous people that has its own requirements. So if I can refer the court in this same document I handed up on the next paragraph, paragraph 42 on the next page, where the Special Rapporteur says, as a general matter, decisions of the state should be made through democratic processes in which the public's interests are adequately represented. Procedures for notice to and comment by the general public often appropriately reinforce representative democratic processes for state decisions. However, special, differentiated consultation procedures are called for when state decisions affect Indigenous people's particular interests. Such special procedures are justified because of the nature of those particular interests, arising as they do from Indigenous people's distinctive cultural patterns and histories, and because the normal democratic and representative processes usually do not work adequately to address the concerns that are particular to Indigenous peoples who are typically marginalized in the political sphere. So what it's saying is that it says specifically ordinary notice and comment may be enough, but it's not enough for Indigenous people. So in this duty, the Special Rapporteur says, it's at paragraph 63, I don't need to take your ladyship there, but it applies whenever a legislative or administrative decision may affect Indigenous peoples in ways not felt by the state's general population. And in such cases, the duty applies in regard to those Indigenous groups that are particularly affected and in regard to their particular interests. And so it seems clear that it does apply here, and it seems, I think, uncontentious that this development does have a particular impact on Indigenous peoples and triggered this duty to consult. And that the duty to consult is above and beyond whatever duty might apply in any ordinary circumstance that didn't affect Indigenous people. So here, it may well be the case that the process that goes through the National Heritage Resource Act, which, and particularly through 38.3e, is sufficient to meet that requirement if it complies with the requirements of international law. And so we should interpret that consultation requirement to meet the requirements of international law.
Can you just pause for one moment? You don't have to look at the clock. We will give you your fair hearing. If we go over time, I think we will, all of us will be patient enough to give you your...
Thank you, lady.
Yes.
I'm aware that my learned friends
I think your submissions
may wish to...
I think your submissions are very important, so I don't want to rush you.
I'm not rushing, lady, I promise.
Yes, but I don't want
I'm
you to
actually on time to finish in half an hour, so everyone will be glad to hear.
Yes, I just want to reassure you it's no problem if you sit a bit over time.
Thank you, milady. I appreciate that. So I'm now turning to the second last submission. This is really the core, which is what is the content of this duty?
Yes.
And we've drawn out 6 elements that we say are, for the purposes of this case, very important. The first is that consultation must take place as early as possible before the decision is taken. So it must take place during the initial stages of development or investment planning. So it can't take place at some point after important decisions have been taken. Consultation that happens later, for example, about the further consultations after the decision to proceed with the development, about the details of what the garden may look like or what the memorial may look like, that's not what we're talking about here. This is consultation that happens right at the beginning. The second is that the consultation must be in line with Indigenous people's own traditions and must be with a representative entity. Now, my lady, I'd like to refer the court here to the second authority in this small bundle that I handed up. It's at the flag, and it's a decision of the Inter-American Court on Human Rights. So, of course, the Inter-American Court is interpreting the American Convention on Human Rights, which isn't binding on us, but the provisions are very similar, and there seems to be a convergence, excuse me, my lady, between thinking across what this right means, whether it's in the African system, the international system, or the American system. So it's on that basis that I'm relying on these authorities, and you'll see they refer to ICCPR and Human Rights Committee authorities. So if I can take the court to the next page, it's in footnote 161. And what the court says is that it's line 5 of that footnote. Begins at the end of line 4. In addition, the said communities must be consulted in accordance with their traditions and during the initial stages of the development or investment plan. And so that's an important point, that it must be in accordance with their traditions. So when this consultation happens, it must be respectful consultation. I'll come to this in more detail, but it's the general duty is good faith consultation with the goal of reaching agreement. That's the overarching duty. And that means that you've got to consult with Indigenous people on their terms, not on the developer's terms or the state's terms. And so this reflects what was said by a panel of the International Labour Organization. The quote is in paragraph 65 of our heads. I don't need to take your ladyship there, but what the committee said is that talking about representativity, which is obviously an issue in this case, who represents the First Nations communities that have an interest in this property. And what the committee says, the committee is aware that it could be difficult in many circumstances to determine who represents any given community. However, if an appropriate consultation process is not developed with the Indigenous and tribal institutions or organizations that are truly representative of the communities affected, the resulting consultations will not comply with the requirements of the Convention. they're talking there about the ILO conventions for indigenous and tribal people, but again, our submission is that the duty is similar across the treaties that are binding on South Africa. And coming back to this judgment of the Inter-American Court, what the court says again in footnote 161, beginning right at the beginning, good faith calls for the absence of any type of coercion by the state or by agents or third parties acting with its authorization or acquiescence, and is incompatible with practices such as attempts to destroy the social cohesion of the communities concerned by either corrupting the community leaders or establishing parallel leaderships or by negotiating with individual members of the communities. So the emphasis is on, and the duty rests on the state to do this, to ensure that they're consulting with representative bodies that truly represent the community, and that they're not taking sides in internal community disputes, and that they're not consulting only with certain sections of a community and not with other sections. That would not constitute compliance with the international law obligation. In South Africa, we don't yet have formally recognized Khoisan leaders. The traditional Khoisan Leadership Act has been passed, but no councils have been established yet. So there isn't a formal statutory recognized entity with which the state can consult at present. And so that does make it perhaps more difficult for the state or for developers, but the duty remains the same. So that's the second point, that it must be consultation with a representative entity and in terms of the traditions of the indigenous people. The third requirement is that it must be with the goal to reach agreement. Now, what exactly does that mean? I think it's quite helpfully summarized by the Special Rapporteur in paragraph 49 of this little bundle I handed up to you. The first document, paragraph 49, is on page 17. And this is what the Special Rapporteur says. These principles are designed to build dialogue in which both states and indigenous peoples are to work in good faith towards consensus and try in earnest to arrive at a mutually satisfactory agreement. As emphasized earlier, the duty of states to consult with indigenous peoples and related principles have emerged to reverse historical patterns of imposed decisions and conditions of life that have threatened the survival of indigenous peoples. At the same time, principles of consultation and consent do not bestow on indigenous peoples a right to unilaterally impose their will on states when the latter act legitimately and faithfully in the public interest. Rather, the principle of consultation and consent are aimed at avoiding the imposition of the will of one party over the other, and at instead striving for mutual understanding and consensual decision-making. So again, that's quite a clear standard in terms of it's a goal-based standard. That's got to be the goal of your process. It may be that sometimes you cannot reach agreement, you cannot reach consensus. And at that point, if they're acting in the public interest and they've followed consultation with that goal in mind, the state can act against the will of indigenous peoples. It's not a veto right. But it's more than just, well, tell me what you want to say and I'll look at it. It's more than that. So it's a more intense duty than we would ordinarily have, decision makers would ordinarily have under our administrative law. Under our administrative law, it's a notice of the decision and opportunity to comment. It's not a process of trying to reach mutual agreement. That's a very different type of process. And that's what international law required in this case. If I could, just on the next page of that document, paragraph 51, the Special Rapporteur talks about the element of confidence building conducive to consensus. And he says at the beginning of paragraph 51, in order to achieve a climate of confidence and mutual respect for the consultation procedure itself should be the product of consensus. The Special Rapporteur has observed that in many instances, consultation procedures are not effective and do not enjoy the confidence of indigenous peoples because the affected indigenous peoples were not adequately included in the discussions leading to the design and implementation of the consultation procedures. So the indigenous people need to be involved also in the design of what is the consultation going to look like. Consultation about consultation. But that's a requirement in order for there to be confidence, because the Special Rapporteur points out that there's often mistrust on behalf of Indigenous peoples because of their history of deprivation, both of government and of private interests. And so you need to build trust in order to conduct this type of agreements, consensus-seeking practice. You first need to have agreement about what process are we going to follow. Finally, the final point I want to make is in the next paragraph, paragraph 52. At the beginning, the building of confidence and the possibility of genuine consensus also depends on a consultation procedure in which Indigenous peoples' own institutions of representation and decision-making are fully respected, as explicitly required by the Declaration and the ILO Convention. So again, the state can't disregard an Indigenous people's form of representation or its form of internal decision-making because it's inconvenient for consultation purposes. The Shell case is a good example of that. Shell said, well, we've consulted with your traditional leaders. And the people said, but that's not good enough because as a matter of our customary law, that isn't adequate for consultation with the people to just talk to our chiefs or to our kings. You have to come and talk to us. And the court agreed with them and said, that's not sufficient just to say, well, you can just go talk to the chiefs because that's easier. You must actually engage according to the traditions and with the accepted representatives of the Indigenous people, the way they see it. The fourth point I want to make, milady, is that the obligation to consult cannot be outsourced to a private party. This is an obligation that rests on the state. It's South Africa that's ratified these international covenants that create this duty. And the Special Rapporteur makes this point at paragraph 54. So it's on the next page, page 19, beginning at the end of the third line, where the Special Rapporteur says, the state itself has the responsibility to carry out or ensure adequate consultation, even when a private company, as a practical matter, is the one promoting or carrying out the activities that may affect Indigenous people's rights and land. In accordance with well-grounded principles of international law, the duty of the state to protect the human rights of Indigenous peoples, including its duty to consult with Indigenous peoples concerned before carrying out activities that affect them, is not one that can be avoided through delegation to a private company or other entity. And then at paragraph 55, the Special Rapporteur has observed several instances in which the state hands over consultation obligations to the private company involved in a project. In addition to not absolving the state of ultimate responsibility, such delegation of a state's human rights obligations to a private company may not be desirable and can even be problematic given that the interests of the private company, generally speaking, are principally lucrative and thus cannot be in complete alignment with the public interest or the best interests of the Indigenous peoples concerned. So when the court is considering the statutory framework here, the HIA is produced by the developer. So its obligation is on the developer to produce the HIA. But the obligation is on the state. Normally to be Heritage Western Cape, in this case it's on the provincial decision makers, to ensure that consultation happens. So if the consultation is going to happen through a developer, that may be permissible, but the ultimate obligation to ensure that the consultation was adequate, that it met the requirements of international law, still rests on the state. The fifth point that I want to make, milady, is that the consultation is an end in itself. So the right is to be consulted, to be part of the process of deciding what happens to your land. So it's not adequate to say, well, ultimately, what you're going to end up with is good for you as Indigenous people. You should be happy with it. It doesn't matter that you weren't consulted in the process. Even if that's true, even if the ultimate outcome is a desirable outcome, that will never remedy the lack of consultation, because it's another form of dispossession of Indigenous people to exclude them from decision-making. And that's what this right is trying to protect. My sixth and final point I want to make on the content of the duty is that the degree of participation that's required will vary from case to case and will depend on the impact on the Indigenous people's culture. And this, if I can just take your ladyship back a few pages to paragraph 47 of the Special Rapporteur's report. It's on page 16, where the Special Rapporteur says, necessarily, the strength or importance of the objective of achieving consent varies according to the circumstances and the Indigenous interests involved. A significant direct impact on Indigenous people's lives or territories establishes a strong presumption that the proposed measure should not go forward without Indigenous people's consent. In certain contexts, that presumption may harden into a prohibition of the measure or project in the absence of Indigenous consent, and then talks about the two situations in which that's recognized. But the important point, ladies, that if it's a very light impact on a community's culture, it might be that a lesser degree of participation or consultation will suffice. And when it's a very, very intense, so many of these cases that come to the international courts are about large groups of people being removed from their ancestral lands for development. That's the case in the Ogik case, in the Poma Poma case, where they're denied of water and eventually forced to stop farming llamas and alpacas. In the Enderwa case, similarly. So where you're forcibly removed from ancestral lands in order for development to occur, that's when you're getting towards the requirement of consent. So the court, in order to determine exactly what's required, needs to look where on that spectrum is this case. But wherever it is on the spectrum, the elements that I've mentioned to your ladyship before still hold. It still has to be good faith with an object to reach agreement. It has to be with representative entities in accordance with the traditions of the Indigenous people. It cannot be outsourced to private parties, and it's an obligation above and beyond an ordinary administrative procedural fairness obligation. So that leads me to the final submission I want to make, which flows on from this, which is about free, prior, and informed consent. So there are instances in international law where, although this is still seems to be somewhat of a matter of debate, but it seems that there are some instances in international law where you need not only to consult with an Indigenous community, but you need their consent in order to engage in a certain type of development. And we refer in the heads of argument to the Poma Poma case, which is a court of the Inter-American decision of the Inter-American Court, which suggests that applies whenever there's an intrusion on cultural rights. And my client doesn't adopt that position. The position it takes is the one endorsed by the African Commission in the Enderwa decision, which is that any development or investment projects that would have a major impact within the Enderwa territory, the state has a duty not only to consult with the community, but also to obtain their free, prior, and informed consent according to their customs and traditions. The terminology we use in our written submissions is a development that would substantially compromise the group's cultural integrity. And so the question for the court would be, is this the type of development that would substantially compromise the group's cultural integrity? And in our view, it's a difficult case, but we submit that it would not, that free, prior, and informed consent would not be required in these circumstances. While the First Nations communities have a very deep connection to this land, and not questioning that in any way, it's not the type of decision in international law that would require consent. But it does fall at the far end of requiring very, very careful consultation, very respectful consultation, and trying very hard to reach agreement with all the affected communities about what is going to happen. So milady, that concludes my submissions, and ultimately it's for the court to determine whether, once it's listened to the factual submissions by the applicant and the respondents about what the nature of this consultation process was, what did the HIA specialists do, what did the AFMAS report do, what was the nature of that, were people excluded voluntarily or involuntarily, was there adequate consultation with the First Nations communities involved in light of the principles that I've set out, and then make a determination. And that will fit in 38.3e, which requires consultation. And what that consultation means, when it affects Indigenous people, this court should interpret that to be in line with the requirements of international law. Those are my submissions.